are now going to begin our legal panel, and we are so excited to hear what their insights are and what they have to say. I'm now going to pass it off to Jean-Pierre to introduce the panel and begin our discussion.
Thank you so much, Elisa. Good afternoon, everyone. How are you all doing? Wonderful, wonderful. My name is Jean-Pierre Brutus. You can call me Jean-Pierre or JP. I'm a host of this fourth annual Reparations Symposium. I just want to thank Robin and First Repair for inviting me to be a host this year. This is my third symposium, and it's really, really nice to see it grow and develop into what it is today. So it's really been an honor and humbling experience to be part of this. Also, I just want to say that Evanston and this hotel are special to me in some ways. I first stayed in this hotel in February of 2008 when I was an admitted graduate student in the PhD program, the Department of Black Studies at Northwestern. I was part of the third cohort. And it was also in that time that I found out that I would also be part of the JD PhD program at Northwestern as part of the third cohort as well. So Evanston and this hotel always have a special place in my heart. It's my honor to introduce our wonderful speakers today. We've got two great panelists and some wonderful insights about a legal framework for reparations, both at the national level, the state level, and the international level. I think we're really going to have a wonderful discussion, and we will have some robust time at the end for Q&A. And so I hope you all are prepared to ask invigorating and insightful questions. And so it's my honor to introduce our first speaker for today, Lisa Holder. Lisa Holder is president of the Oakland, California-based Equal Justice Society. Known for her groundbreaking appointment as a member of the California Reparations Task Force and more than 20 years of experience as a civil rights litigator and scholar. Lisa has made EJS a leader and premier coalition partner in the reparations movement in California and nationally. Under Ms. Holder's leadership, EJS continues to build its dynamic civil rights practice to dismantle discriminatory school discipline and the school-to-prison pipeline, create a just and equitable legal system, promote and protect Black women's health, and combat white supremacy and the extremist forces that threaten the multiracial democracy for which we all should strive. Ms. Holder is a nationally recognized, award-winning trial attorney specializing in equal protection, education equity, employment discrimination, constitutional policing, and international human rights law. In 2019, she drafted AB 241 and 242, the laws that now require all judges, attorneys, court staff, and health professionals to undertake continuing education on bias elimination. In 2020, she served on the steering committee for the Proposition 16 campaign to repeal California's ban on affirmative action. Ms. Holder received her Bachelor's of Arts degree from Wesleyan University and her JD from New York University School of Law, where she was a distinguished Rhodes Tilden Scholar. And now for our second speaker, Dr. Amara Enyia is a strategist and public policy expert on city and state policy as well as international affairs, with expertise in Africa, Latin America, and Central Asia. In her addition to her role as president of transnational advocacy organization of Global Black, she also serves as the interim co-executive of the Movement for Black Lives and senior fellow at the Institute on Race, Power, and Political Economy at the New School in New York City. She also serves as a strategy advisor for organizations, companies, political campaigns, and public sector institutions globally. Dr. Enyia is a leader in residence for policy and change with the Atlantic Institute and also serves as a chairwoman of the International Working Group for the United Nations Permanent Forum on People of African Descent and chairwoman of the Working Group on Global Economic Systems, Institutions, and Policy. Amara holds a bachelor's degree in journalism and bachelor's degree in political science. She also holds a master's degree in education, a master's degree from the London School of Economics, a law degree where she focused on international law, and a PhD in education policy with a specialization in evaluation. She serves on the board of Global Strategists Association, Pakistan Journal of Urban Affairs, the Chicago Community Loan Fund, and Chicago Neighborhood Initiatives Microfinance Group. She also serves on the National Advisory Board of the Public Banking Institute and is a 2020 inductee into the Illini Media Company Hall of Fame. Dr. Enyia maintains proficiency in Igbo, Spanish, French, and Portuguese, and was named a Public Policy Global Leadership Fellow with the Global Strategists Association. Please make a round of applause for our wonderful speakers today. So I want to pass it over to our first speaker, Lisa, and ask her, what are the building blocks for a coherent reparations legal defense strategy?
So really, I'm going to give you sort of the 4 cornerstones for a coherent strategy to defend reparations. The 4 cornerstones: first, you have to have a very sort of strategic ideological framework. Everything is embedded within that. Then you have to have a fierce doctrinal constitutional scholarship that really sort of underpins your framework, right? You gotta understand the Constitution, and you gotta understand the law, and you gotta understand legal doctrine. You also need a very, very strong communications narrative, and a narrative that is holistic, that brings people together, that goes beyond the Black community, right? And that is, that really sort of creates a framework for repairing this nation and building a multicultural, multiracial, inclusive democracy, right? And so that's part of your narrative framing. And then finally, you need a very, very strong mobilization strategy. Now, I was part of the California Reparations Task Force from 2021 to 2023. Many of you may have heard about the work that we did. One of our deliverables was an 1,100-page, essentially racial justice report and historical analysis of racism and discrimination in the state of California and in the entire country. We worked for 2 years to put together this historical analysis. We spoke to well over 100 experts, social scientists in every walk of life, and used their scholarship as a critical underpinning for our report. We also spoke to thousands of Black Californians to get their narratives, and people from age 7 to age 107 to give us their stories, their anecdotes about discrimination in the past that they experienced and the ongoing forms of discrimination that they were experiencing in California. And not only did we speak to thousands of people through public comment in over 30 hearings that we held in the 2-year period, but we also used a lot of research materials to gather information and gather narratives from Black Californians. So polling, sending out, all different types of polling documents to thousands, tens of thousands of Black Californians. And then we used all of those narratives to lay the groundwork and lay the foundation for the report and for the recommendations that we finally unfolded and gave to the legislature in California. In total, we gave the legislature over 115 recommendations. So 115 laws and bills that needed to be passed in California to repair the harm. And the approach that we took it was not just a check in the mail. We really wanted to change systems change every single system in California, the criminal justice system or the criminal legal system, the education system, the housing system, the banking and finance system, et cetera. And so the 115 bills that we wrote essentially for the legislature to start to pass really ran the gamut, right? And really dealt with all of those different sectors. So why is a legal strategy so important to us? Well, because frankly, we are the first state that has really gone into depth, and that we are now creating a reparations infrastructure and actually passing reparations laws. So reparations is real. It is happening in California. And the ancestors, up until today, we have spent the last 200 years, since the day after emancipation, people have been talking about reparations. And now it is being realized. Now it is happening in California. In this legislative session, we got 8 out of the 12 reparations bills that we put forth, signed and passed by the governor. We got the governor to commit to giving a $12 million line item to help the Black Caucus continue to push those 115 bills forward. And so reparations is happening now. But what does that mean in terms of legal strategy? It's really critical in California for us to have a coherent legal strategy, because we know that they're coming after us. Now we have bills and statutes on our books in California that are unapologetically reparations bills. They are unapologetically race conscious. They are unapologetically centering Black people. And so we know that the counterinsurgency forces out there are targeting California, and they have a very, very coherent legal strategy that they're going to be utilizing to undermine all the work that we have done. And so in this implementation phase, it's very important for us to be mobilizing movement lawyers and to be and to work on putting together a very, very strong, fierce, cohesive legal strategy, so that when these bills get looked at by the judges, which will happen when we get sued, they can survive judicial scrutiny. So I'm going to introduce, I told you one of the most important things is to have a strategic and ideological framework, right? That sort of serves as the construct for your legal strategy. So let's see if this works. Okay. Agenda? Okay. Okay. Let's start with that one then, that's fine. So the legal strategy that we are designing in the Equal Justice Society, which is the racial justice and legal organization that I run, is one that is focusing on what we're calling DEI to reparations defense, right? You may have seen there is a flurry of activity by and movement lawyers across the country to defend DEI. They are not bringing reparations into that conversation, and they need to bring reparations into that conversation, because the fact is that DEI, CRT, multicultural education, and all of the book bans that we're seeing across the country, and reparations are part of one continuum, because from a legal scholarship perspective, we will all be reviewed as race-conscious policies and race-conscious programs, right? And so we are all in the same boat, whether you're doing DEI work or reparations work, CRT work, or fighting these book bans and focusing on saving multicultural education. We are all in the same boat, and we will sink or swim together. And for folks who are organizing ferociously around protecting DEI, they need to understand that if reparations goes down in the courts, DEI goes down in the courts, because they are all race-conscious programming. Will all be reviewed as race-conscious programming under strict scrutiny. So I want people, I don't want to get too doctrinal and legal here, and wonky, but I do want, we created this Venn diagram that really shows the overlap between DEI, diversity, equity, and inclusion, and we should use those three words, diversity, equity, inclusion. Don't call it DEI. We have been, I don't know, we have been taught by the right at this point to refer to it as DEI. But when you, from a narrative perspective, it's important to say diversity, equity, inclusion, because you want to be able to say to someone, wow, you're against diversity, equity, and inclusion? That's interesting. It's not as powerful when you say you're against DEI, but when you say you're against diversity, equity, and inclusion, that really sort of says something. So this Venn diagram really looks at critical race theory, DEI, multicultural education and book bans, and reparations, and how they are all overlapping as race-conscious programming from a legal perspective. We go to the next slide. Okay, I'm going to skip this slide to keep it moving. Now, one of the things that people need to understand with race-conscious programming is that everyone is saying, oh, it's illegal. It violates the 14th Amendment. DEI violates the 14th Amendment because it's race-conscious. Reparations violates the 14th Amendment. That is the programming and the messaging that the right is using to confuse people and really getting people to just sort of give up before they even try. But the fact is that legally, constitutionally, you are allowed to do race-conscious programming. And although we do have 6 justices on the court who are going to push back on that, we have 3 justices on the court who understand that and who are going to defend that fiercely, including Justice Brown Jackson. And it's very important to understand her positioning on it, because she's taking an originalist stance. Typically, folks on the right take an originalist stance, right? And so we're sort of using their own strategy against them. And she's explaining that when the so-called framers designed the Reconstruction amendments, the 13th, 14th, and 15th Amendment, they did it in a race-conscious way, right? They understood that these were laws to protect recently freed, emancipated folks, right? And so they understood that it was to protect black people, right? And so when the 13th, 14th, and 15th Amendment were drafted and instituted, it was about protecting black people and protecting people who had been marginalized, right? And so from an originalist perspective, the 13th, 14th, and 15th Amendment continue to protect the rights of black people, right? And so you can do race-conscious policy. The most important thing when you are doing race-conscious policy is to do it in the way that the court has told you to do it. And there's a whole series of cases where the court has told us, you can do race-conscious policy, but you just have to design it very meticulously and carefully. So from a very practical perspective, and I'm trying to keep this practical because I know we have a lot of activists out here who are actually doing the work. I'm going to go to a slide that talks about what your reparations program should look like and why. Give me 1 second. See if I can find it. Croson? Okay, there's a very important case. It's called Croson. And in the Croson case, the court, this is in the 90s, the court told us that, okay, if you're going to do race-conscious policy, you're going to have to make sure that you're using a very, very, very strong, sound methodology. You're going to have to collect a lot of information, which means you're going to have to give the court narratives and anecdotes from people who continue to experience discrimination. The court is not interested in the experience of discrimination from the past as much as they are interested in the experience of discrimination in the present and the danger of future discrimination, right? And so it's really important to give a historical framework and to set it within a historical context, but you have to be able to show the continuing harm of discrimination. You have to be able to show that slavery, that 150 years of slavery, or 200 years of slavery, 100 years of Jim Crow, and then 60 years of post-civil rights apartheid is actually continuing today. It has created a structure where the harms continue today. And then you have to show each and every one of those harms. You have to collect anecdotes from real people showing how those harms are continuing. And then you always have to have a underpinning. You must leverage social science. So you have to collect information from social scientists who understand how race continues to play in all of these outcomes, you know, that we're seeing in every different sector, right? And how race continues to create these disparities. And so you have to collect and gather that social science. So if you have these foundational pieces, you can move forward and do race-conscious policy, right? But you have got to have the goods. That's why we did an 1,100-page report. That's why we had, 30 public hearings in a 2-year period. That's why we spoke to thousands of Californians and used all kinds of instruments to collect the anecdotes from thousands of Californians. And that's why we spoke to over 100 social scientists and gathered the social science theories from the last 15 years as the underpinning for our report. And what does that mean? It now means that we can go in front of any judge, we can go into any court, and we can say, we have the goods to show that discrimination is continuing. We have the goods to show that it's a violation of the 13th Amendment badges and incidents clause, right? Because the harm that's continuing is a badge and incident of slavery, right? And if you go directly to the 13th Amendment language, the Reconstruction laws, those laws prohibit the continuation of badges and incidents of slavery, and they give Congress and legislators a mandate to make laws that will obliterate the badges and incidents of slavery, right? And so we have it under we have a pathway forward under the 13th Amendment. We have a pathway forward under the 14th Amendment because it allows for race-conscious laws. And we have a pathway forward. I have 3 minutes left. Yeah. And we have a pathway forward. You can take a picture of this. Under all of these statutes, all right? I know there's not everybody in this room is a lawyer, but you do need to understand that there are a series of constitutional laws and statutes that allow for us to do this kind of race-conscious program. And as long as we can give the court the goods to meet a very high level of scrutiny, then we can continue to do race-conscious programs. So don't listen to the right's narrative about how race-conscious programming and reparations are fundamentally illegal and unconstitutional. That is disinformation. That is part of the disinformation narrative that we have to push back against. Okay. There's just 2 more slides that I'm going to show you. I like to keep it really practical here. And so I want people to know what they're up against and who they're up against. Ugh. Okay. Is this the right one? Oh, this is a mess. This slide looks really messed up. But what you need to know is that this is the opposition. This is what they look like. This is who they are, right? Unfortunately, my slide's kind of messed up, so you can't see. It's interesting how they have, they have names like Students for Fairness and Equity or Equality, when in fact they are doing everything to undermine equal opportunity, right? But they always use those words and sort of co-opt that language to confuse people. Again, even their very names are part of their disinformation campaign. But these are the groups who are suing folks and bringing hundreds of court cases from DEI to reparations, so DEI, anti-CRT, anti-multicultural education, and anti-reparations cases. And so you should know who the players are. And the last thing I'm running out of time, so the last thing that I will do is, if you want to take a picture of that, I recommend that in terms of, I didn't have a lot of time to talk about narrative, the narrative piece, which is, and a uniform communications strategy across the nation, which is actually very critical strategically to bolster the legal defense that we're going to be employing. But I do recommend the work of Kimberly West Falcon, who is a brilliant professor at Loyola Marymount, who really has sort of laid out what the opposition's narrative looks like, what their legal strategy looks like, and how we combat it through public education, through reframing, through having our own proactive narrative and agenda that keeps us moving forward, even though there are so many headwinds against us in this moment. Thank you.
Thank you so much, Lisa. We really appreciate your presentation, and I look forward to your Q&A for Lisa after Dr. Amara's presentation. I just want to make two brief points and just highlight Lisa's point about the Reconstruction Amendments. The preeminent historian of Reconstruction, Dr. Eric Foner, consistently points out that we should think about the Reconstruction Amendments together, the 13th, 14th, and 15th, particularly because they are a second founding for the U.S. They are a break from what the framers intended in 1789. And so it creates a new republic. So maybe some of you are familiar with the idea of France being in the Fifth Republic, right? In many ways, the US with different constitutions is in multiple republics. But I just want to add this addendum, right? Historically, it's been the federal courts, at least the federal government, that's been the protector of civil rights for black folks, even though the Supreme Court has been hostile, right, to racial justice for its history, except for a brief blip of time, and that's the period from 1954 to 1968, which folks call the Warren Court, right, and which we idolize as being in support of racial justice. We could make the argument that we are not entering a new republic in which the main character of racial inequality, particularly in the view of the Supreme Court, are white people, right, the realm of white grievance. So Justice John Roberts, Clarence Thomas, right, Donald Trump, they see the main character of white grievance as white people, and racial justice is organized, and the use of the 14th Amendment is organized around them. So I just want to point that out as well when we're thinking about how to attack the narrative of that of white supremacy and racial inequality at a structural level. I do want to pass it over now to Dr. Amara for her presentation, and then we'll have Q&A. Dr. Amara, please.
Thank you so much. Thank you to Robin and the rest of the First Repair team for just the thinking and the energy to put this convening together for a number of years. I know it's a heavy lift and much appreciated. And also thank you to Lisa for opening it up and doing the heavy lifting for this session and providing just so much critical context, not just for lawyers, but for non-lawyers, because this work is going to involve all of us, whether we are lawyers or not. And so I want to appreciate you for sharing that and for paving the way for my brief remarks, which are actually going to be quite brief. I know that there are some questions that folks have on what was shared. And so I'm going to lend just a bit of an international lens to what's been proffered, to maybe color it a bit with that framework. I did want to mention, and it's perhaps a bit controversial, but I think it's really important that Lisa really leaning into the importance of narrative. And one of the hallmarks of the US judicial system, it really is, if we go back a few decades, this notion of precedent is one of the biggest challenges. And the last 60, 70 years of public policy have actually really laid bare why some of the big legal decisions of that time actually represent challenges for us today. And I'm speaking specifically of the shift to creating more palatable arguments versus focusing on remedy. Justice requires a remedy. And so if we think about, for example, the Brown v. Board decision, which made the case around the importance of diversity. So diversity as an intrinsic good, and that paved the way for desegregation. But what was actually the issue in our schools was the fact that black schools with black children, were under-resourced intentionally, that they did not have the resources for materials, the resources for their teachers, the resources for all of the other things that we know exist in our schools. And so the remedy was not necessarily that they needed to be mixed up with other children. Of course, there's a value to that. But the remedy was that the resources that they had been intentionally deprived of actually needed to be allocated to those schools so that the teachers could teach, so that the students could learn, and so on and so forth. And so this is a critical legal precedent. Why? Because most of our public policy following that goes along those same lines. So this notion that there's some intrinsic, not harm, but the notion of living around black people, for example. So if housing or access to housing was a challenge, the voucher system actually would then place people in other neighborhoods outside of the community where they reside, right? When actually it's that many of our communities that live on the west side of Chicago had been intentionally divested by government historically once the black folks got there. And so the remedy is not that I now have to move out of my neighborhood on the west side of Chicago to live around other folks. I mean, that's fine if I want to do that, but that's not the remedy. It is that all of the things that I'm entitled to, I should be able to get in my neighborhood because that is the obligation of the government of that municipality. What we have instead is now our people have to now get vouchers to go outside, which then feeds into a notion that there's something inherently wrong with being around your people or with homogeneity. And our legal precedent from that time follows that course to now where the same narratives are being used against us. That now if it's a race-conscious policy that prioritizes black folks, well, that's not, we are supposed to be, what is it, race-blind or colorblind. We strive to be a colorblind, equal society. The issue was that it was never equal. And so justice requires a remedy. And we moved away from that for expediency, I would argue, and I recognize that this is controversial, but it is part of many of the challenges that we're facing, at least domestically, when we try to advance this reparations agenda, because now our words are being used by other groups, right? So I just wanted to offer that to hopefully get us to think about how the precedent, legal precedent, but also public policy precedent has created a set of circumstances that we now have to be very, very creative to work around so that we actually get to the justice part, which is the remedy for the historic crimes against humanity. And that leads me to my second point, is the framing. Many times when we talk about reparations, and this is not just on the domestic level, but also in the international landscape, there is a lot of emphasis on harms. We know what the harms are. Much of our research, our scholarship outlines the harms. I think Dr. Joy, where's Dr. Joy? You have one of the best, most brilliant thinkers who outline the harms, the results of the crimes. From a legal standpoint, there has to be focus on the actual crimes against humanity. That is absolutely critical. Why? Because the crimes are related to the justice, and the crimes expose the perpetrators of the crimes. Oftentimes when we talk about the harm and when the focus is on the harms, it's done in a way that it's this nebulous, we just materialize as harmed people with these nebulous actors that are never explicitly named, and we're trying to make our way, we're trying to heal ourselves of our own accord without actually holding to account the perpetrators of the crime. And we have to lean more into the crimes from a legal standpoint. Otherwise, it will obscure the perpetrators. And then when we move to seek remedy, we'll be thwarted in our efforts. So I wanted to raise that point first and foremost. And why this is especially important, particularly in the international context, is because the perpetrators are still here. They have become normalized. They are part of the day-to-day discourse. The notion of chronology is important because folks will think that it's just for the transatlantic slave trade, and it's not. As Lisa pointed out, it is not just slavery, it is all of the subsequent manifestations of the exploitation, which are continuing today. So we can talk about the slave trade, but we also have colonialism, we have neocolonialism, we have neoliberalism. In fact, we are living in this hyper-imperialist state right now, driven by militarism to perpetuate the exploitation of our people around the globe. That's happening in the present day. And so if we know that that is the case, then the remedy is not just for what happened 400 some years ago. It is present remedies that we have to extract from the present perpetrators. So I just want to throw out a few names. I want to see if any of these institutions are familiar to folks. So you can just raise your hand if you're familiar with any of these institutions. The International Monetary Fund. Okay, some familiarity. The World Bank. A lot of familiarity. The G7. The World Trade Organization. The United States. No, I'm just kidding. I'm just kidding. Just kidding. But you understand my point. These institutions represent the ongoing exploitation and extraction from the slave trade. Racial capitalism is a global phenomenon. Anti-Blackness is a global phenomenon. These institutions, which are largely global, are the mere representations of the initial from the slave trade till the present day. And so the institutions actually bear a responsibility for the perpetuation of the crimes against humanity. When we have what they call a debt crisis of African countries, for example, where they are forced with colonial currencies. If you are in Francophone Africa, the franc CFA is your currency. That is a colonial currency that ties you to France. That means your resources, everything is extracted for the benefit of France. Those whose currency is tied to the US dollar. Anyone, if there's a Nigerian in the room, inflation here is nothing compared to what they're dealing with there. Those colonial currencies are still controlling those very same people who were exploited and brought over and trafficked. Crimes against humanity. Loans given by the IMF with with restrictions, with conditions that require you to be more in service of creditors than your people, which means that an IMF has more control over your sovereign state than the government of that so-called sovereign state. These are present institutions that are implicated in the perpetuation of these crimes against humanity. And so from a legal standpoint, we have to be very clear about the connections between these institutions and the harms, the crimes and the harms that our people are experiencing around the world, so that we can mount the kind of strategy that coheres all of us, because we know that what our people in Brazil are facing is very similar. If anyone has traveled to Brazil, if anyone has traveled to our Haitian family, if anyone has traveled to anywhere, Central and South America, Colombia, and you do an analysis of the state of Black people, you will see a similarity, you'll see trends. And all that does is provide more support for the notion that these institutions are operating at a global level in a way that is perpetuating the same exploitation, the same crimes as that existed during the transatlantic slave trade. And so my goal is, because there is a domestic component, of course, to the reparations, reparatory justice work. What's happening in the United States is really an exemplar. And our folks outside of here are looking to see how things are playing out. It is important that we also have that global context, because we are not operating in a silo and we're not operating on an island. As global Africans, we have to recognize the global systems and institutions that are still perpetuating our exploitation. That allows us to actually mount much stronger strategies, and it allows us to build power necessary to advance this agenda, because it is not just the purview of the lawyers. It is not just the purview of the educators. It is going to require mass movement, mass mobilization, which feeds into the narrative that is important to change the systems and the structures that govern our existence. And the last thing that I'll end on is that of the 5 components of reparations, compensation, satisfaction, acknowledgement, apology, cessation, and guarantees of non-repetition. Cessation and guarantees of non-repetition for me is most critical, because that implicates the systems and the structures. It cannot be reparatory if the systems and structures are still in place and intact. And so if we consider that component as we are developing our litigation strategies, either at the domestic level and the international level, I think we can actually harness the momentum that we have globally to mount legal and litigation strategies that can be impactful and that can help us to usher in the next paradigm, which we are actually right on the cusp, and that is our responsibility. Thank you.